Okay, hello class. We are here with criminal law week 8, kind of week 8 because of the finals schedule that we had about halfway through the semester and because of spring break. But we do know that it is chapter 9 and that's going to cover rape and sexual assault for us. So there are a lot of topics to be covered. Just hang in there with me on this one. And just like a lot of the rest of the chapters, at the end, it should be pretty common sense to tell what is rape in today's world. I think that the only reason that it might be a little tricky is because the common law era of rape was not very straightforward. And we're going to see that in a second here. So the topics that we do have to cover today are going to be force, threat, or fear, lack of consent, the affirmative defense of consent that we have nowadays, mens rea and mistake of fact, rape by deception, rape of drugged or intoxicated victim, statutory rape, rape trauma syndrome, and rape shield laws. So let's start by looking at what forcible rape was under common law here. Okay, so back under common law, the two most important elements of forcible rape were obviously A, force, and B, lack of consent. Now, back then, there was not a specific mens rea, meaning that this was a general intent crime. So, a prosecutor was required to prove that a defendant engaged in sexual intercourse and intended to use force or threat of force to accomplish that act. A prosecutor did not need to prove that a defendant intended to engage in non-consensual sexual intercourse. Okay, so what does that mean? Those obviously seem like conflicting statements there. So look at the third bullet point here. So two things, engaged in sexual intercourse and intended to use force or threat of force to accomplish that act. So a prosecutor doesn't need to show that a person intended to engage in non-consensual sexual intercourse. As long as there was a lack of consent, that was an element that was met. Okay, so look at the intent part. It's just that they intended to use force. It is not that they intended to engage in non-consensual sexual intercourse. But remember, there did have to be a lack of consent. So essentially, they didn't need to be aware necessarily of the lack of consent, just that they used force and that there was a lack of consent. Okay, so this common law era is also known as the pre-reform era because obviously this is a little bit confusing here. So at some point over the years, they got to a much more cohesive understanding of what forcible rape means and what it means nowadays, of course. So let's look at force, threat, or fear, one of the big topics that we're going to talk about here. Courts looked to the victim to supply evidence of the defendant's use of unlawful force and had the victim show that they used the utmost resistance during the attack. So during a trial for a rape in the pre-reform era, a victim had to kind of prove herself to the court or himself and show that, hey, I fought as hard as I could, I resisted as much as I could, and unfortunately the defendant was still successful in his attack, in his rape. Now, this was to persuade judges that a defendant's use of force was sufficiently harmful to justify the conviction and that a victim's claim was credible. Now, nowadays, that's ridiculous, right? So over time, the utmost resistance requirement was replaced with sufficient resistance. But now it's gone even further, and it now is that a defendant's provocation of a victim's reasonable fear may justify a conviction in the absence of a victim's physical resistance. So think about that. Why is that the way that it is now? I think one of the obvious answers to that is that a woman could very well risk her life by fighting back, right? If a woman fights back hard enough and the attacker gets completely frustrated and loses his mind, he could kill her, he could harm her, he could severely do some damage to this victim. And the other obvious answer is that people have different responses to this type of attack, different behaviors. Think fight or flight or freeze. That's the third one, right? So there's a lot of victims that just freeze. And then back then, of course, they couldn't show utmost resistance. So how is that fair, right? So that is why now we have a completely different standard of reasonable fear is what we mostly see nowadays. And we're going to see that type of response in a later slide when we talk about rape trauma and the different behaviors and the evidentiary topics that are often discussed in trial nowadays for these types of cases. So let's look at the first case in our book, People v. Iniguez, and that's going to be found on page 281 of your textbook. So what happened in this case? The defendant woke the victim by walking naked into the room where she was sleeping, pulled down her pants and began fondling her. He then had non-consensual intercourse with the victim. Now, the victim here did not resist or attempt to escape the defendant's unwanted sexual contact. The victim testified that she did not attempt to resist or attempt to escape because she was paralyzed with fear, like we just talked about. And at trial, the defendant was convicted of rape. So it goes up to the appellate court, and the issue for the appellate court is whether the evidence was sufficient to show that the victim's will was overpowered by fear of bodily injury. And the appellate court says yes. If a victim genuinely feels fear of bodily injury, which is our subjective component here, and that fear is reasonable, our objective component, then a rape conviction is valid. So here the victim testified that she froze because of her fear that the defendant would do something violent if she reacted. She was also so distraught afterward that she hid in the bushes, and when a friend picked her up, the friend could barely understand her. She was so distraught, so incoherent after what had happened. So the appellate court says, yeah, the conviction is valid because the jury could have reasonably concluded under the circumstances that the victim reasonably feared unlawful bodily injury, and then that fear, she did indeed feel that, and it was a reasonable fear, and she froze during the sexual intercourse. So this is a good illustration of what we have generally nowadays, is that if you subjectively, you yourself feel that fear and it's genuine, and somebody in your shoes would have also felt that fear, that it is reasonable essentially, then yes, your will has been overpowered and you've been raped in that situation. That is a valid conviction for rape, okay? So let's look at the reason for the rape law reforms. Rape has historically been dramatically underreported, and the probability of apprehension of a suspect, even after law enforcement is notified, has been historically low. And convictions have been historically low. Why is that? Because just like we have been talking about the different behaviors for rape victims, one of those behaviors is to automatically go shower or go clean up, go get that off of you. And that is the unwitting destruction of evidence by victims. A lot of forensic evidence can be destroyed that way. Additionally, there are special evidentiary rules, which we will talk about. One of those evidentiary rules that resulted in low conviction rates was the utmost resistance requirement that used to be commonplace, okay? So that one is gone now, but that was one of the reasons for a low conviction rate for these types of cases. Another reason is that it's often just the victim's testimony. A lot of this, usually there's not a witness, Like we talked about, a lot of the forensic evidence can be destroyed. It's almost always happens in a not crowded place or at night, and it's often just the victim's testimony, and it can turn into a he said, she said. And one of the other reasons is jury attitudes towards victims. I'm sure we've all heard it. Something tragic happens to somebody, and inevitably someone's going to say, well, what was she thinking? What was he thinking? Why would she go out dressed like that? You know, she was asking for it. Attitudes like that, they still exist. They absolutely still exist. So that is just another reason for one of the reasons for a historically low conviction rate for these types of crimes like sexual assault and rape. So that is why we as a country have reformed our laws over the years to try and raise that conviction rate and get justice for victims that have been the victim of this type of crime. So let's go back to force. You'll see in the textbook that there are 3 different definitions of force that have come up over the years in this type of law, in rape and sexual assault law, okay? And you'll see that over on starting on page 289 here. So let's look at the first one. Force as a threat that overcomes the will to resist. So when the element of force appears in a rape statute, then force is an essential element of the crime. But no particular amount of force, either actual or constructive, is required to constitute rape. And force may exist without violence, certainly. So what are we looking at then? If the acts and or threats of defendant were reasonably calculated to create in the mind of the victim a real apprehension due to fear of imminent bodily harm, serious enough to impair or overcome her will to resist, then such acts and threats are the equivalent of force. Okay, so all this is saying is that if I say or do something that causes you enough fear, and that fear is reasonable to overcome your will to resist, then I have met that definition of force. Okay. Okay, so we also have the definition of force as psychological pressure. So where the statutory definition of force includes an act that coerces the victim to submit by threatening to use force or violence on the victim, then force may include a threat that may be implied as well as express. So implied threat, what does that mean? If I point a gun at you and I don't say a word, is that a threat? Of course it is, yeah. So that's just an implied threat. An express threat is where I say, I am going to shoot you if you don't do as I ask. So force may consist of the imposition of psychological pressure upon a person who, under all of the circumstances, is vulnerable and susceptible to such pressure. So the law recognizes that a command by someone who has a position of authority and who is forcibly able to back up that authority need not be accompanied by an explicit threat in order for such a command to be effectively and inherently coercive. So, a position of authority, that could be a police officer, that could be somebody's boss. If somebody's boss coerces their employee, their secretary to do something sexual of nature, that could be force as psychological pressure. Okay, so just a different definition that we're looking at here. And remember that the force can be implied as well as expressed. And then lastly, we have force as the act of penetration. This is a more broad definition of force that equates it with the type of force required for a battery. So where the crime of sexual assault is defined by statute as the commission of an act of sexual penetration with another person, where the actor uses physical force, the term physical force should just be interpreted as any amount of force that results in offensive touching. So this definition is not interpreted as force used to overcome the lack of consent, okay? So let's move on to non-consensual sex without force. In a majority of states, non-consent alone without force may establish criminal liability. Okay, why is that? Because of course we want to criminalize non-consensual sex even if there's no force used. Okay, like we talked about, what could happen if a victim utilizes the utmost resistance? It could escalate the violence and she or he could be seriously harmed. But back in the pre-reform era, defense counsel could attempt to raise reasonable doubt about the lack of consent by arguing that consent was implied by the victim's ultimate submission and the failure to demonstrate sufficient resistance. So back in the day, one of the defenses would be, she didn't fight at all. She must have been consenting. She must have liked it. She must have wanted this to happen. That's why she didn't fight back. That's not going to be nearly as effective as a defense today, okay? So let's look at the lack of consent. Resistance. Here's an example of a statute that explains it pretty well from Nebraska. There is a lack of consent when the victim expresses a lack of consent through words, or the victim expresses a lack of consent through conduct. The victim need only resist either verbally or physically so as to make the victim's refusal to consent genuine and real, and so as to reasonably make known to the actor the victim's refusal to consent, and a victim need not resist verbally or physically where it would be useless or futile to do so. So all this is saying is that if a victim says no and she means it, and the actor should reasonably know that the victim is not consenting, then that is enough. That's all that this is saying. And it goes on to state further that, let's go back to our scenario of somebody having a gun, pointing it at a victim. Look at subsection D here. Someone need not resist verbally or physically where it would be useless or futile to do so. If someone's got a gun pointed at their head and the defendant is making it known that they're going to commit a sexual assault or a rape, in that situation, a victim would not have to say no or physically fight back because it would be useless or futile to do that. In fact, it might even be dangerous, right? The defendant might shoot somebody that unhinged, really. So Nebraska has a very good example of a modern day statute about lack of consent and where that falls nowadays, okay? So let's look at another definition of lack of consent called manifested unwillingness. This is where communication from the victim to the defendant, in which the victim must manifest her unwillingness objectively. If the victim objectively communicates lack of consent, and the defendant subjectively fails to receive the message, he's still guilty. So if the victim says no, and she means no, and the defendant just thinks she's messing around or she doesn't mean it, he's still guilty. He can't say, oh, I didn't know she actually meant it. I thought that was, part of this little game. I thought that was part of what was going on. Nope, that's not going to be a defense. If the victim objectively and reasonably communicates that lack of consent, it's not going to be good enough for the defendant to say, oh, I didn't really understand. So what do we ask in this definition of lack of consent? We ask whether a reasonable person in the circumstances would have understood that the victim did not consent. We look at it through an objective lens. There is no subjective lens for this lack of consent definition of manifested unwillingness. And let's look at another definition of lack of consent, and this is going to be our absence of affirmative agreement. So permission to engage in sexual intercourse under this definition must be affirmative and it must be given freely, but that permission may be inferred either from acts or statements reasonably viewed in light of the surrounding circumstances. people need not expressly announce their consent to engage in intercourse. That's just not practical, right? That's not how it works. It's not, people don't do that every time they have sexual relations. Permission is demonstrated under this definition when the evidence is sufficient to demonstrate that a reasonable person would have believed that the victim had affirmatively and freely given authorization to the act. Failure to resist here is not consent. Let's make that clear. Like, we want that to be clear throughout the whole lecture for this, is that failure to resist does not equal consent, okay? Let's talk about withdrawal of consent. Most courts hold that withdrawal of a victim consent, even after the beginning of sexual intercourse, can still lead to conviction for the crime of rape. Why is that? Because people can change their minds, right? Something can happen during sexual intercourse that makes somebody change their mind. And if someone changes their mind, the other person doesn't just get to keep going. That is rape, because then it does what? It turns into non-consensual sexual intercourse, and that's still going to be a crime. We want to criminalize any type of non-consensual sexual intercourse, because nowadays that's pretty much always going to equate to rape. Now, consent is, on the other hand, almost always going to be an affirmative defense. So when the legislature removes the lack of consent element from a modern rape statute, a court may decide that this policy decision was not intended to preclude judicial recognition of the defendant's ability to raise consent as an affirmative defense. So all this means is that when the prosecution does not have to prove lack of consent, like when they have to prove force and they have to prove intent, they don't have to prove lack of consent in a jurisdiction where that's the case. The defendant can still show that the sex was consensual to avoid conviction. And why? That's common sense, right? Just break it down this way. There's nothing to punish if there's consensual sex. The government can't punish that. So if a defendant shows that the sex was consensual, everything's fine then, right? If he shows that at trial. Now, let's remember, what is an affirmative defense? An affirmative defense is when the prosecution proves their elements, but the ball goes into the defendant's court, and he can prove by a preponderance of the evidence, 51%, that the sex was consensual, then he's going to be acquitted because he's proven beyond his burden that the sex was consensual, and there's no need to punish that. The government cannot punish that. So let's look at State versus Kapersky here. The state charged defendant with first-degree sexual assault, also known as rape. A state statute defined the offense as sexual penetration when a person overcomes the victim by force, threat of force, express or implied, or coercion. The defendant at trial introduced evidence related to whether the victim consented to sex, and he requested a jury instruction on the defense of consent. But the trial court said no. They said, you're not getting that request. They did allow the defendant's attorney to argue the issue of consent before closing arguments, but did not give an instruction to the jury regarding consent. At the end of the trial, the jury convicted the defendant. So the issue, after it goes up on appeal, is whether consent is a defense to a charge of first-degree sexual assault or rape, and if so, whether any evidence was adduced in support of that defense. Here, the ruling was yes and yes to both of those questions. Consent can operate as a defense because consent may operate as a failure of proof in regard to the essential element of the use of force, or that the victim was overcome. So back at the trial, the defendant had testified that the sex was consensual, so there is some evidence that the jury must consider. The legislature obviously cannot criminalize consensual sex like we just talked about. So here the conviction is reversed because the jury was not instructed on the theory of defense of consent, and there was at least some evidence for the defense of consent. So when there's some evidence to a defense, the trial court has to give the jury the instruction to consider that. That was not done here, and that is why the defendant's conviction is reversed. So the main takeaway here is that consent can absolutely be a defense to rape. Okay? That's just common sense, guys. We can't criminalize consensual sex. So, recognition of the consent defense. It has to be objectively reasonable for the defendant to conclude that consent was given by the victim. Okay? It doesn't make sense if his belief is unreasonable. Then everybody could say, "Oh, sorry, I didn't know. I thought it was consent," and just walk away. That's not the point, right? The consent has to be reasonable. So the affirmative defense of consent is to be raised when the rape statute includes no reference to a lack of consent element. Remember what we talked about. Affirmative defense means that defendant must prove his defense by 51% of the evidence or preponderance of the evidence in order to be acquitted. Okay? Now, the reason that the affirmative defense of consent is to be raised when the rape statute includes no reference to a lack of consent element is because it's an affirmative defense. A complete defense would be if they didn't prove one of the elements. Okay? So this is where a prosecutor does not have to prove lack of consent. In jurisdictions where that's the case, then the defendant can raise the affirmative defense of consent to show that he did not overpower the victim, that this was consensual sex. Let's take a look at mistake of fact defense. If a victim did not consent, but the defendant made a good faith, reasonable mistake about that fact, then he cannot possess the wrongful intent about consent that should be required for a rape conviction. So here it would be the prosecutor's burden to prove beyond a reasonable doubt that a defendant did not have a good faith, reasonable mistaken belief in consent. So in other words, a defendant would obtain an acquittal if he raised a reasonable doubt as to whether he had such a belief. A majority of state courts recognize this defense, and you have to remember it has to be reasonable, okay? If somebody reasonably believes that what they're doing is consensual, then they don't have the mens rea, the intent to commit the crime of rape, right? If somebody reasonably believes that the other person is consenting, then they're not trying to rape someone. So let's take a look, because the textbook brings it up, the marital rape exemption. This is completely gone now. So back in the day, it used to be that people could not be criminally liable for raping their spouses. Sounds crazy today, right? But that used to be the case. Not that long ago, honestly. Your grandparents' generation, probably. You know, that used to be the law. Now, all states have abolished this. Some states allow for lesser punishment for spousal rape, but that's just some. So all states have completely abolished this. They have all said that, yes, you can absolutely be criminally liable for raping your spouse. It didn't take long for, the rest of the country to realize that, yeah, that's obvious. That's common sense. Can't believe that we had the marital rape exemption in the first place, but that is completely gone now. So let's talk about, is there a death penalty for rape? No, not since 1977, and not even for child rape. The U.S. Supreme Court overruled the death penalty for rape in a series of cases back in the late 70s. And the U.S. Supreme Court reasoned that non-homicide crimes against individual persons cannot be punished with the severe and irrevocable penalty of death because that violates the Eighth Amendment against cruel and unusual punishment. Okay, so just a point to note that there is no death penalty for rape. not even for child rape in any state, because the United States Supreme Court has said no, that's too far. So let's take a look at the rape of a drugged or intoxicated victim. Back under common law, the crime of rape included sexual intercourse with a sleeping, unconscious, or drugged woman, because such victims are incapable of giving consent or resisting unwanted sexual acts. Most state codes now include a definition of rape that either requires the defendant to administer drugs to the victim or requires that the victim should be in an impaired state because of drugs when the rape occurred. It's also common for rape statutes to apply where a victim is incapable of giving consent because of physical or mental helplessness. So all that we're trying to grasp for this concept here is that why is this a crime? Because they can't consent and they can't resist. Because they can't, it's non-consensual sex. The United States wants to punish non-consensual sex, of course. And of course, if someone is impaired or drugged or asleep or unconscious, they can't consent. So that's going to be a crime. Okay? Statutory rape. Consent is not a defense to statutory rape charge. Now, what is statutory rape? Statutory rape is when somebody has sex with a minor, with a child. So why is consent not a defense? Because minors are presumed to be unable to legally consent. Of course, they can't sign a contract. They can't go to war. They can't join the military. Then, of course, they can't consent to sexual intercourse. Now, mistake of fact as to age, that never used to be a defense, but now about 1/3 of states endorse the defense of reasonable mistake of fact. So what does this look like? You're out at the bars and you're 20, let's say you're 23 years old, and in walks what you believe to be a 19-year-old woman. And in fact, she's 16. She's dressed up. She has a fake ID. She looks older than she is. She tells you that she's 19 or 20, and y'all have drinks at the bar and you go home and you have sex. In 2/3 of states, you're going to be criminally liable for statutory rape, even though all of those facts existed. But in 1/3 of states, you can say, she told me she was 19. She looks like she was 19. She had a fake ID that said she was 19. I thought she was 19. What do you want me to do? Check her social security number? So 1/3 of states, you would most likely be acquitted in that situation. 2/3 of states, however, you would be criminally liable for the felony of statutory rape. So it's just one of those things where it's can be argued on both sides why either side is important. Internet crimes. So the statutes are intended to protect children from online predators. Let's go to page 307 of our book for a good example here. We have a piece of legislature from New Hampshire that says no person shall knowingly utilize a computer online service, internet service, or local bulletin board service to solicit, lure, or entice a child to commit acts described in any offense under a provision that includes a long list of sex crimes. Almost every state has this, if not every state. Okay, Texas has this, obviously New Hampshire has this, every state has this. Why? Because we know that there are online predators out there. We see that in the news all the time. People posing as children, talking to children anonymously online. I'm sure you guys have seen Omegle and all that crap that's out there. There are plenty of hazards and threats to children online. So every state has adopted something like this to protect children from this. So they especially make it a crime to do any of these things on the internet, trying to entice a child to do something. So that is always going to be a criminal act, all right? and it's designed exclusively to protect children from online predators. So let's look at some evidence rules for rape prosecutions, because they do get a little bit tricky and a little bit different than most criminal charges in pretty much every state, especially Texas too. So state codes allow expert testimony to be admissible on any subject sufficiently beyond common experience that the opinion of an expert would assist the trier of fact. So it's allowed in rape prosecutions concerning the behavior of rape victims, like we talked about before. It's allowed to dispel common misconceptions about how rape victims behave, and to allow the prosecutor to rehabilitate a rape victim's credibility if the defense counsel argues that the victim's conduct is inconsistent with a claim of rape. Expert testimony is not allowable for the prosecutor to prove the elements of the crime. So let me try to explain this a little bit differently for y'all. When we have a trial for a sexual assault, the state can call a prosecutor to explain to the jury that rape victims behave differently. Everybody reacts differently to rape. And here's why. Here's what's going on in the brain. Here's what studies have shown. So maybe that's why she didn't resist, or maybe that's why she didn't call the cops right away, or maybe that's why she didn't tell anybody right away. They can use that to explain that to a jury. A prosecutor cannot use expert testimony to show a lack of consent or a use of force or anything like that, not to prove the elements of the crime, just to help explain why a victim may react the way that they did. Now let's also talk about rape shield laws. All states have some type of this, Texas included. These laws essentially provide that evidence of a victim's prior sexual conduct is not relevant to prove her lack of credibility and willingness to consent to forcible sex. Why? Because the goal of these laws is to prevent a sexual assault trial from degenerating into an attack on the victim's reputation, rather than focusing on the relevant legal issues. So if somebody has had sex every single day for a year, if it's not relevant to whether or not she was raped, which it's presumed not to be, defense counsel can't bring that up to show that she's promiscuous, because they don't want to focus on her past. They want to focus on the alleged criminal act itself. Now, there are exceptions. A good example is Federal Rule of Evidence 412. The exceptions are a specific instance of sexual behavior by the victim to prove that a person other than the accused was the source of semen, injury, or other physical evidence. So what does this mean? If my defense is that it was someone else that was the source of the semen, then I can put on evidence of a specific time that the victim had sex to show that it was somebody else's semen, for example. Under letter B, another exception is a specific instance of sexual behavior by the victim with respect to the person accused of the sexual misconduct offered by the accused to prove consent. So you can show that the victim has had sex with the defendant before and that it was consensual sex. You can offer that as evidence. Letter C, evidence the exclusion of which would violate the constitutional rights of the defendant. That's just going to be your general catch-all. If there's some situation where you believe that your client's rights would be violated without this evidence, then you can attempt to put on that evidence. But A and B are the two big exceptions that we see for rape shield laws. So let's take a look at a few hypotheticals for us here. Hypothetical 1 is going to be found on page 311 for you guys. It's kind of hard to fit the facts into these little PowerPoint slides, so please make sure you go back and you take a look at these hypotheticals if you haven't already. So number 1, victim meets defendant at a bar. They talk for a while, then victim says she needs to leave to get home to her child. Defendant asks for a ride home, which the victim agrees to. When they get to the defendant's home, defendant asks her to come up. Victim says, no, I'm giving you a ride home. That's all this is. However, the defendant takes the keys out of the ignition, then asks again and says, are you going to come up? So the victim, a little bit scared now, follows defendant into his apartment and says, if I do what you want, will you let me go without killing me? Defendant essentially says yes, and defendant and victim have sexual intercourse. Then victim immediately leaves and reports the incident to the police, tells her friend, all of that. Is there sufficient evidence to convict the defendant? Yes. Under the facts, and they're more detailed when you read it for yourself, so please do that. Under these facts, her will was overcome by fear. That is enough. That is going to be rape. That is sufficient evidence to convict the defendant of rape. Going on to hypothetical number 2, we have the dorm room situation here. The defendant and the victim are college sophomores. The defendant was just hanging out in his dorm room when the victim came looking for defendant's roommate. Roommate wasn't there. Defendant invites victim to hang out, which she agrees to. The victim sat on the floor, and the defendant, who was sitting on his bed, moved to the floor with her. The defendant eventually straddled her and fondled her while she repeatedly said no. They eventually had intercourse, or rape rather. The victim runs downstairs, tells her boyfriend, who reports the incident to police. Is there sufficient evidence to convict the defendant? This is a competing theory here. Under Commonwealth v. Berkowitz, under this hypothetical number 2, the element of forcible compulsion was not met. So while we may have some sort of lesser sexual assault, they find that there cannot be a conviction for rape here because under, under Pennsylvania statute, the element of forcible compulsion was not met because there was not enough force used. So go back and read that one to try to get a better understanding of how different jurisdictions define force differently, like we talked about towards the beginning of this lecture. And like we said, it illustrates different definitions of force that we discussed. So let's go to the intoxicated victim under hypothetical number 3. Victim goes to a bar with her friend. After drinking there for a while, victim's boyfriend and defendant show up. The 4 of them agreed to go to the boyfriend's house where they drank some more. Victim's friend and friend's boyfriend go to bed. And they noticed that when they went to bed that the victim seemed incoherent. At that time, the defendant was already laying on the floor. Sometime during the night, the victim awoke to the defendant having sexual intercourse with her. She screamed and woke up her friend and her friend's boyfriend, who took her to the hospital. But at trial, the defendant testified that the victim told him she wanted to have sex. So, under this hypothetical, the prosecutor wants this instruction. Consent is not a defense to the crime of rape defined as sexual penetration, where the victim is incapable of giving consent because of intoxication. In determining whether the victim was incapable of giving consent because of intoxication, you must consider all the circumstances in determining whether the victim's intoxication rendered her unable to exercise judgment. The defense counsel, however, wants this instruction. Consent is not a defense to the crime of rape defined as sexual penetration, where the victim is incapable of giving consent because of intoxication. If the victim was incapable of giving consent because intoxication rendered her unable to exercise reasonable judgment, and if the defendant knew that the victim was unable to exercise reasonable judgment because of her intoxication. Whose instruction is correct here? Think of everything that we've talked about, even going back to previous lectures for this class, previous weeks. Defense counsel's instruction is correct because it better identifies the mens rea. Why? Because if the defendant didn't know that she was unable to exercise reasonable judgment because of intoxication, then he couldn't have understood a lack of consent.
and he needed to intend to have sex with her without her consent or with force. But if he truly thought that what he was doing was consensual, then he wasn't trying to commit the act of rape. So I hope that makes sense for you guys. Please email me if you have any questions. And I look forward to seeing y'all when I get back from out of the country. So we will see you guys probably on, I want to say it is March 28th or 29th. We will finally be back face to face, and I'm looking forward to it. And hope y'all had a safe spring break and continue to be safe in whatever it is that y'all do. Take care.